Hi, I'm Judge Dan Slayton. Each year, domestic violence threatens over 4 million people. Victims are both men and women, and the abuse can leave devastating emotional and physical wounds. Children of abused parents are silent witnesses to violence and are often abused themselves. Arizona sees 100 domestic violence-related homicides a year. Drug and alcohol abuse can make an abusive relationship worse, and poverty can make it harder to reach safety. Arizona law provides tools to reduce domestic violence. These tools are called orders of protection, and this video will show you how to get one and what to do if an order of protection is issued against you.
Hi, I'm Judge Dana Hendricks. How does the law define domestic violence? Domestic violence is the use of violence or the threat of violence between people who are or have been in an intimate relationship. The abuser may be a relative, spouse, boyfriend or girlfriend, or someone the victim lives with. There doesn't have to be physical injury for there to be domestic violence. Domestic violence may have occurred if the other person has or tries to endanger you, threaten, intimidate, or harass you, interfere with the custody of your children, trespass on or damage your property, restrain or kidnap you or hold you prisoner, assault you, display a deadly weapon or threaten you with a deadly weapon, or if the person photographs, videotapes, films, or records you without your knowledge. If you or your children are in danger, you may contact law enforcement, victim assistance shelters, or hotlines. You can find a list of these resources at the Self-Help Center. In an emergency, you should call 911.
If you've experienced domestic violence, you can ask the court to order the other person not to contact you or come near you. This is called an order of protection.
If you're involved in another case, like divorce or custody case, let your attorneys know about the order of protection. If that case involves children, ask an attorney how an order of protection might affect custody or visitation.
Please understand, though, that an order of protection is meant only to protect. It is not a tool for getting either temporary or permanent custody or visitation.
You may include your children who are under 18 on your request for an order of protection. Except for your children, though, the court probably won't issue an order of protection you request on behalf of someone else. That person should make their own request. There are two kinds of protective orders. One is called an order of protection. The other is an injunction against harassment. The one that's right for you depends on your relationship to the other party. But first, let's look at the words the court uses to identify those parties. The person asking for the protective order is called the plaintiff. The other party is called the defendant. An order of protection is appropriate if the defendant is the plaintiff's spouse or former spouse, the parent of the plaintiff's child, someone who lives or has lived with the plaintiff, or the plaintiff's parent, grandparent, child, grandchild, brother or sister, whether by blood, court order, or marriage. If the defendant doesn't fit into any of those relationships, an injunction against harassment may be appropriate. An injunction against harassment orders the defendant to stop harassing, annoying, or alarming the plaintiff. An injunction against harassment may be appropriate if the defendant is a neighbor, a stranger, or a boyfriend or girlfriend the plaintiff hasn't lived with. Remember, the harassment must be a series of acts directed at you. An injunction against harassment can't be issued if someone makes harassing statements about you to another person. And an employer may request a third type of protective order. That's called an injunction against workplace harassment. It's used to prevent violence in the workplace.
The court provides a packet of forms and instructions for you to use in an order of protection case. The plaintiff can use the packet to ask for an order of protection, and both parties can use it to ask for a hearing on an order of protection. The packet is available for free here at the Self-Help Center located at the County Courthouse, 200 North San Francisco Street in Flagstaff. If you can't come to the Self-Help Center, or if it's more convenient, you can find the packets available for downloading on the Internet. Here's the web address. Keep in mind that an abuser can track the Internet sites you visit on your computer. It may be safer to use the computer at your local library, a friend's house, or your workplace. You can call the Self-Help Center at 779-6656 or toll free at 877-806-3187. Or you can email the Legal Services Center at legalservices@co.coconino.az.us. The Legal Services Center is open Monday through Friday, 8 a.m. to 5 p.m.
Hi, I'm the Law Library Assistant. To ask the court for a protective order, first read all the forms and instructions in the self-help packet. Then complete the forms called Order of Protection and Injunction Guide Sheet and Petition. The first blank on the petition asks for the court's name. How do you decide which court to use? You can ask for the protective order in municipal court, also called city court, or in justice court. But if you and the defendant have a divorce or custody case in superior court, you must ask for the protective order in superior court. If you're filing in superior court, use the case number from your other court case, for example, your divorce case number. If you're filing in municipal court or justice court, leave the case number blank. Pay close attention to describing the domestic violence. For each event, enter the date it happened and where it happened, and state exactly what happened. Please don't make statements such as, the defendant harassed me or the defendant abused me. You must tell the judge specifically what happened. Use extra paper if necessary. Label the extra paper Exhibit A and attach it to the petition. The court may not issue a protective order without this information. On the guide sheet, remember to enter the defendant's birth date if you know it. When you've completed the guide sheet and the petition, fill out just the caption on all the rest of the forms in the packet. The caption includes the information about the court and the parties, as well as the title of the form. On these forms, the court will fill in the rest of the blanks. If you want hearing on a protective order that's already been issued, first read all the forms and instructions in the self-help packet. Then complete the form called Request and fill in just the caption on the form called Hearing Order.
Now that you've completed your forms, you need to file them with the court. Bring all the forms you filled out to the court. If you are filing in municipal or city court, please note the address of the court nearest you. There are municipal courts in Flagstaff, Fredonia, Page, and Williams. If you're filing in justice court, also note the address of the court nearest you. There are justice courts in Flagstaff, Fredonia, Page, and Williams. There is only one Superior Court in Coconino County, located in Flagstaff. To file in Superior Court or in Flagstaff Justice Court, come to the County Courthouse at 200 North San Francisco Street. When you get to the counter, give the clerk your forms. The clerk will give you back a set of copies with the date stamped on them. There is no fee to file an order of protection. But remember, the clerk does not have the knowledge to answer questions about what you should do or how to fill out the forms. Arizona law prohibits anyone but an attorney from answering legal questions. The clerk is trained just to process your papers.
After you file your forms, the court will hold a hearing to consider what you've asked for. If you ask the court to issue a protective order, the hearing is held the same day you file your papers. This is called an ex parte hearing, and it's just between you and the judge. If you or the other person asks for a hearing on a protective order that's already been issued, the court will let both parties know the date and time of the hearing. and both parties must appear at the hearing. We'll talk more about this kind of hearing later in the video.
Once the judge signs the protective order, the defendant must get a copy of it before it will go into effect. The copy is delivered by the sheriff through a legal method called service. Until a defendant is served, they are still allowed to contact and approach the plaintiff. Take the set of copies the clerk gave you to the sheriff in the county where the defendant lives and ask them to serve it on the defendant. There may be a fee to serve an injunction against harassment. The sheriff in Coconino County should file proof of service with the court. A sheriff outside the county should give you that proof to file yourself. In either case, make sure it gets filed within 7 days of service. Without proof of service, the protective order is difficult to enforce.
Hi, I'm Joy Delahaye, Deputy Court Administrator. If the plaintiff and defendant live in the same home, the order of protection may give the plaintiff exclusive use of the home. This means the defendant must stay away from the home, even if they live there too. In these cases, the defendant may return to the home one time only to pick up personal belongings. The defendant must have a law enforcement officer accompany them on this visit. An order of protection also might order the defendant to turn in any firearms they own to law enforcement. In these cases, the defendant must turn over their firearms within 24 hours of receiving service of the order of protection. When the order of protection ends, the defendant may ask law enforcement to return their firearms.
A protective order is valid in every state no matter where it was issued, and it ends 1 year after it's served. Only the court can end the order before then. Remember, the plaintiff cannot waive it. The protective order doesn't guarantee the plaintiff's safety. It's just one tool to help prevent violence. You should always keep it with you and call the police immediately if the defendant violates it. You should also give copies to your family, neighbors, and the children's schools if appropriate.
If you and the defendant have a court hearing together, tell the bailiff about the order of protection when you enter the courthouse, and they'll escort you to the hearing. Keep your address and phone number current with the court.
If the defendant asks for a hearing and the court can't find you, the court may end the order of protection if you don't appear at the hearing.
Either party can ask for a hearing on the order of protection at any time. The court will let both parties know the date and time of the hearing, and both parties must come to the hearing. If the defendant requests a hearing, it will be held within 10 days, or 5 days if exclusive use of the home was ordered.
Both parties should prepare for the hearing by watching the How to Represent Yourself in Court video at the website below.
Both parties must be ready to testify about why the court should grant their request. Please remember to bring any witnesses you need, the original and 3 copies of any evidence that might support your case to your hearing. Remember, both sides will be allowed to question any child witnesses. If you think it's necessary to have your child testify, notify the court before the hearing. Please understand, however, under the law, children are allowed to testify under certain circumstances. Please make arrangements to leave your children at home or bring an adult to supervise them outside the courtroom.
In this video, you've learned how to get an order of protection if you or your children's safety is at risk. And you've learned how to get a hearing after an order of protection is issued. Let's review the steps.
To get an order of protection, first get the packet from the Self-Help Center. Fill out the forms, file the forms with the court. The judge will then hold an ex parte hearing with you to decide whether to issue the order. After the order is issued, have law enforcement serve the forms on the defendant. The order of protection is valid for 1 year after it's served.
To get a hearing on an order of protection, Get the packet from the Self-Help Center, fill out the appropriate forms, file those forms with the court. The court will then let both parties know the date and time of the hearing. Remember, both parties must appear at the hearing.
This video has given you a basic overview of orders of protection. Whenever you become a party to a court case, especially if children are involved, we encourage you to speak with an attorney to make sure you understand your legal rights and responsibilities.
Make sure you read all the information in the self-help packets we've shown you today. You may also contact Legal Aid for assistance at 928-774-0653. They provide free legal services for low-income clients. Finally, the plaintiff may seek assistance from Victim Witness Services at 928-779-6163.
We hope this video has been helpful to you. Thank you.